How a whistleblower firm selects what whistleblower cases to litigate. Over the years, people have offered millions of dollars in potential fees up front and on the back end to take potential whistleblower cases, and we've said no. We turn down the overwhelming majority of cases that come through our door. Not because they aren't real problems, a lot of times they are, but because a whistleblower case is a years-long war, and we only like to go to war when we think we're going to win it, and with a client who is worthy. But just because we take it doesn't guarantee any result, because more fail than succeed, unfortunately. But today, I'm going to walk you through a little about how we decide what whistleblower cases we are going to litigate. I'm Jason T. Brown. I'm the founding partner of Brown LLC. Before I had the privilege and honor of representing individuals in private practice, I also had the great privilege and honor of serving the country as an FBI special agent and a legal advisor. And I did some great work, and the teams did great work back then. Our current firm, Brown LLC, is built on former Department of Justice alumni, including another partner who spent years as a senior trial counsel in the Department of Justice unit that prosecutes False Claims Act cases nationwide. We've been ranked by Lex Machina as one of the most prolific False Claims Act firms in the world, if not the country, and our cases have helped the government recover over $1 billion. But again, past results do not guarantee future success, but we'd love to succeed. We handle these cases, these whistleblower cases, coast to coast and worldwide on contingency, which means we only are paid if we succeed, which is why we're extremely selective. Every case we take, we're invested in it with our own money, our time, our years, and we are aligned with your interest. So here's the framework we look at. First question we ask is, are you an insider or an outsider? An insider is an employee, an executive, a billing manager, a compliance officer, someone who has personal knowledge about the scheme in the scienter, the wrongdoing. You saw the meetings, you have the emails, you know where the bodies are buried. And more importantly, you can point to where those bodies are buried and you can help prove it. You don't need to prove it right away, but you need to show the government that you can. The False Claims Act has what's called a public disclosure bar. If the fraud is already out there in the public domain, your case can get dismissed unless you qualify as an original source with independent material knowledge. Insiders usually clear that bar. They also help us develop the case and let us plead it properly. Outsiders often do not. Now, outsider cases certainly can work. Analysts who reverse engineer fraud from data miners, competitors who see rigged bidding or customs fraud. We've evaluated cases like that. We've taken them and even settled them. But the burden is much heavier, and we underwrite them much more skeptically unless you have insight and visibility to the scheme in its entirety. The second thing we look at is damages. And let me be candid with you. Our firm, fortunately, is in extremely high stratospheric demand. And as a general rule, we're looking for cases where the fraud against the government exceeds $10 million. Under the False Claims Act, damages are trebled and penalties attached to each false claim. So a $10 million fraud is a serious case for the government and a potential meaningful recovery for the whistleblower. We also look to make sure the defendant is solvent. But here's the nuance. And when I say 10 million, that's 10 million pre-trebling, pre-doubling of the damages. 10 million in actual damages. But it's very nuanced. Damages and liability sit for us on a sliding scale. The bigger the damages, the more extensive the possible damages are, the more challenging the liability picture we can accept. $1 billion fraud may be worth fighting through hard proof problems. But on the flip side, the tighter the liability, the crisper the proof, the insight, visibility, and the ease of making the case, the lower the damages we'll consider. So a smaller case with a smoking gun document can beat a giant case on inference for our evaluation. However, a giant case with a good theory with an insider we'll look at pretty hard. Don't self-reject because you think your number's too small. Tell us the number, tell us how you got there, show us the proof, and we'll do the math. Third, and this is where most cases die, facts versus theories. People call us all the time saying, I think my company is defrauding Medicare, and it's worthy of a call. But when they say it's just a theory versus here are the patient files, here are the billing codes, here are the dates, and here's the email where the director told us to upcode. Well, we know that's the case. I'm not saying for you to go ahead and gather documents on your own. You should make sure you consult with an attorney and make sure you're legally, ethically, and lawfully have access to documents before you forward them to us. Federal fraud cases are pled under Rule 9B, which requires particularity. The 5 W's, who, what, when, where, and fifth W has a W at the end, how. Courts dismiss whistleblower complaints every week because the relator had just a strong suspicion but is weak on the specifics. Details, 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 details. I said that a lot because details are important. When you contact us, the single most valuable thing you can do is name things specifically. Names, dates, amounts, documents you lawfully possess. As a former FBI agent, I'll tell you what every investigator knows. Cases aren't just built on outrage, not based on just theory. They're built on evidence. Fourth criteria we evaluate is you, the whistleblower. We only work with people who we genuinely want to work with. That's not a slogan. Over the years, we've walked away from probably hundreds of millions of dollars in potential fees because the client wasn't someone we could stand next to for 5 years. No amount of money will make us deliberately take on a difficult plaintiff. People offer us money up front. We will not do that if we don't want to work with you. We deal with challenging adversaries every single day. Fortune 500 defense teams, top 10 defense teams, armies of billable attorneys and hours who constantly multiply. We have to confront and combat them. We don't want problems from the inside too. And here's an uncomfortable truth. In litigation, the whistleblower's credibility is the case at times. The government will vet you before it vets the defendant. If your story shifts, if you can't take counsel's advice, if you're pursuing a vendetta instead of the truth, a jury will feel it, and so will the Department of Justice. And they'll evaluate whether they're going to intervene or not. And if you don't come across as unlikable and inconsistent, they probably won't take the case. Nobody ever calls us thinking they're a difficult client. We do the assessment for both of us, honestly, at the start. The whistleblowers we represent are people of integrity who saw something wrong, want it fixed. That's who typically wins, somebody with a noble heart. I'll tell you outright, if you're mean to our intake staff, which some people are for some reason, we just won't take your case. If you demand that you only speak with me, we won't take your case. We're a firm. The firm is an extension of me. If you follow the golden rule and treat others like you want to be treated, we will consider your case. A fifth factor is geography. While we do litigate all over the country and the world, sometimes in conjunction with local counsel at no additional expense to you, not every courthouse and district is created equally. Circuits split on key False Claims Act doctrines. Judges differ in how they apply Rule 9b, how they treat the public disclosure bar, how they handle motions to dismiss, how they handle customs fraud, how they handle PPP loan fraud from an outsider perspective. All those are important to us. Some United States attorneys' offices are very aggressive on fraud. Others are stretched thin. Where a case can be filed and where it should be filed is a strategic decision we make with decades of federal experience, including from the inside. Including me, I have 30 years experience, and we have people such as Tom Morris with even more. So if you're in a smaller state or a tougher circuit, that's not disqualifying. It's just a variable we are going to factor in. 6, the type of whistleblower case. We primarily concentrate on bounty programs, the False Claims Act, the SEC whistleblower program, IRS, CFTC, and the newer anti-money laundering programs. Those that reward the whistleblower with a percentage of what the government recovers. And there where our federal experience creates the most leverage and bang for the buck for you as the whistleblower and better recovery for the government. We unfortunately rarely take standalone retaliation cases because just as much work goes into those as the larger cases. Doesn't mean that we don't feel for you. We do feel for you, especially if you're fired for speaking up. But based upon what we do, we take the bounty cases and we'll take the retaliation cases and bundled with the bounty cases. If you endured real harm, you may have a case. But if your case includes retaliation on top of fraud, which often does, we factor it in. But an individual retaliation case, based upon how high demand we are, it's rare for us to handle. But if it's an individual retaliation case, based on how busy we are, it's rare for us to handle, but not unheard of. But if you call us, we may have some ideas, and we may also be able to evaluate whether you actually do have an underlying bounty case for us to proceed. It's a survey of our framework. We want insider knowledge, meaningful damages on a sliding scale with liability, facts over theories, character of who you are calling, jurisdiction, and the right program. If you listen this far and some of your situation, you're trying to figure out whether your boxes fit all of them, some of them, give us a call. We'll work through it with you. Whistleblower laws generally have a first to file rule. The first relator to file generally blocks everyone behind them under the False Claims Act. Another day, someone else may file your case. Call Brown LLC or reach us through our site for a free confidential consultation. We're former federal insiders fighting for the good guys. If we take your case, we're going to take it to win.